To this discussions from Drinko Hall. This is our Supreme Court Year in Review 90-minute series. I'm Chris Walker. I'm a law professor here at The Ohio State University Moritz College of Law. And I'm really excited about this program. We've got, we had a really blockbuster term. Although the Supreme Court decided only 68 cases on the merits, there are countless that were real kind of blockbuster cases. And today we're going to focus on a set of 6 of these cases that are kind of several of the big blockbusters. We're not going to be able to get to some of the others, but really excited to have that and to have my colleagues here joining us to talk about each case. Now, this program has been approved by the Ohio Bar for CLE credit. So for those that are looking for CLE credit, there'll be polls that show up throughout that you have to fill out. There is a right answer to every one of those questions, but it doesn't matter if you get it right or wrong for CLE credit. And so just make sure that you do indicate, one or an answer so that it'll be logged that you were participating during the full 90 minutes. The way the program is going to work is we're going to spend about 13 minutes on each of these 6 cases or sets of cases with each of our area experts. And we'll have the expert explain the case a little bit, and then we'll have some Q&A along those lines. So if you have questions that you want to ask, feel free to go down at any point down to the Q&A button at the bottom and add your question or comment there, and I'll look to weave that into our discussion as we go. And so the first case we have is the Title VII discrimination case based on gender identity or sexual orientation. And for that, we have Mark Spindelman is going to talk about this case. He's the Isidore and Ida Topper Professor of Law here at the Ohio State University. He writes a lot in the area of intersection of law and culture, including LGBT rights and reproductive justice. So I'll turn it over to Mark so he can talk a little bit about these. Actually, there are 3 cases that were kind of consolidated into one opinion in the Title VII context. So Mark, I'll turn it over to you. Thanks,
Chris. And let me just start, if I may, by a quick thanks to Amy Gallagher for putting the event together, and to all of you for joining us here today. I'm going to be calling this talk Bostock's Constitutionalism. Justice Gorsuch's opinion for the Supreme Court in Bostock against Clayton County, recognizing anti-gay and anti-trans discrimination are forms of sex discrimination under Title VII, has already become famous as a textualist decision. It both is and it isn't. As I sketch here, Bostock's own text subtly but unmistakably points to non-statutory grounds in the public account for its results. First, Bostock's textualism. 2 textual moves from Title VII get Bostock going. One is a conservative biological definition of the statutory term sex. The second is Title VII's expression because of, as in because of sex, which delimits the scope of when sex discrimination is unlawful. On this point, the opinion claims statutory text as authority, but it's really relying on Supreme Court gloss when it announces that the expression because of means traditional but for causation. These 2 moves are the rudiments of standard Title VII doctrine, which Bostock then applies to its anti-gay and anti-trans discrimination claims. Bostock explains that but for a gay man's sex, which makes him a man rather than a woman who's attracted to men, he wouldn't suffer from sexual orientation discrimination. Somewhat similarly, neither would a trans woman suffer anti-trans discrimination, but for the sex she was assigned at birth. Thus, Bostock reasons it's, quote, impossible to discriminate against a person for being homosexual or transgender without discriminating against that individual based on sex, unquote. That's the crux of Bostock's textualist account. It rounds the bases without seeming to depart or departing too much from Title VII's text. Bostock is textualist in this sense. Still, this is a mechanical or wooden textualism, a textualism that refuses to indulge Title VII's original public and legal meaning. As the Bostock dissents note, Bostock's understanding doesn't accord with Title VII's meaning from 1964, and so is wrong. Agree or don't that this matters, Bostock does feel thin as to its public explanation for why the court declares anti-gay and anti-trans discrimination to be categorically protected by Title VII's sex discrimination ban. If Title VII's text, made into doctrine by the court, gets Bostock up to the plate, it simply doesn't on its own direct the direction of the swing. On the question of whether anti-gay and anti-trans discrimination are properly treated as sex discrimination, Bostock's conclusion, obviously, is a judicial choice. Bostock acknowledges this. In fact, Bostock meets the moment of interpretive decision or crisis in different ways. Moments of confident deflection aside, there are also moments of engagement. One deserves mention because of its significance. Well into the opinion, after posing a series of rhetorical questions that curiously challenge its own normative underpinnings, Bostock reaches concerns about neutrality, quote unquote, in unexpected applications of statutory terms. Zeroing in on congressional treatment of quote unquote disfavored groups, odd because Bostock insists Title VII's about individuals, Bostock launches into a brief digression involving the Americans with Disabilities Act. On the other side of this discussion, Bostock's account is general and applicable to the case at hand. I quote, "To refuse enforcement of a statute just because the parties before us happen to be unpopular at the time of the law's passage would not only require us to abandon our role as interpreters, it would tilt the scales of justice in favor of the strong and popular and neglect the promise that all persons are entitled to the benefit of the law's terms." Tacitly, but unmistakably, and sounding a little bit like Justice Kennedy, this is Bostock explaining its interpretation of Title VII. It's telling us why it's included lesbian women, gay men, and trans people within the statute's terms. Bostock is Lady Justice, finding balance with her scales. This is lovely, but disorienting. In saying this, Bostock temporarily gives up the textualist hunt. The move leaves Bostock open to the attacks that arrive from the dissents, saying this is both fake textualism and legislating from the bench. This charge misses the authoritative legal supports for what Bostock does. They are found in cases Bostock studiously doesn't invoke, but that anyway supply the deep legal justification for what it says it's up to. Saying this, of course, is to speak about the Supreme Court's pro-lesbian and pro-gay rights jurisprudence, which until Bostock had only implicitly protected trans people. Bostock now indicates they're included within the law's safe harbors. Importantly, it's this body of constitutional case law that makes it an authoritative legal statement to say, as Bostock does, that all these persons are entitled to equal treatment under the law, and that Title VII should be read that way, no matter how these persons were once regarded in 1964. In this way, Bostock emerges from and returns to deep values of constitutional law. Call this Bostock's constitutionalism. Recognizing this, the statutory textualism of the Bostock dissents, whatever their relative merits as Scalian faith, are legally misguided insofar as they effectively give authoritative interpretive respects to historical forms of anti-gay and anti-trans public sentiment as the basic normative justification for their own textualist law plays. As a rule, the Supreme Court's pro-LGBT rights jurisprudence teaches that those forms of discrimination are not to be given operative legal force, including in the opinions of the law courts. This is why the Bostock dissents, while claiming interpretive fidelity to Title VII's historical meanings, actually disserve and weaken the statute, destabilizing its foundations. They do this by authorizing a constitutionally dubious interpretation of federal anti-discrimination law, which a legislature would be hard-pressed to defend. How can the government that may not carve out LGBT people from its general marriage laws cut them out from otherwise applicable anti-discrimination law rules? Bostock says they can't. As an effort to hold the line against the Supreme Court's pro-LGBT rights jurisprudence, the Bostock dissents have the authority to dissent away, but they do so at the expense of a principled understanding and application of now settled constitutional rules, deepened and extended by Bostock. In this respect, if the dissents are right on their textualism, it's because textualism itself can vindicate propositions that violate the given law, a given law that Bostock follows, making it both a textualist reading and not. Thank you.
This was great. Feel free, audience, to jump in with questions, and same with panelists. If you have questions, maybe for panelists, we can, if you want to get your video on, you can just raise your hand and we'll kind of, go along that way. I've got one question already lined up you from one of your former students, Jonathan Bond, and he says, was the doctrine of textualism exposed in the Bostock decision when 3 self-described textualist judges came to different conclusions for different reasons? As one of your former critical theory students, I'm skeptical that textualism represents a higher form of interpretation. Or does Gorsuch's opinion represent the purest form of textualism, even though it cites to extra legal sources such as precedent, dictionaries, and the like?
So is that the full question, Chris?
There's a little bit more. Do you want the rest of it?
Yeah, totally.
Okay. Aren't all judges just focusing on what they want to focus on to get a desired result? They are human beings after all. Interested to hear your thoughts on the doctrine and its future.
All right, so thank you for the question. It's nice to hear from a former student, as always. So look, I think that there are ways in which one can say about the Bostock opinion sort of overall, that they prove the point that, that textualism as an interpretive method is indeterminate or underdeterminate, and that it's not the sort of quote unquote real reasons for judicial decisions. I think that there are lots of things to commend those views. Here, I think what's interesting is that it's so far, although that point has been sort of, as you noted, there's not yet been enough, I think, attention paid to Justice Gorsuch's opinion, which I think itself is kind of remarkable in giving up the textualist play in this way. I only mentioned one moment of the text, but there are others in which he's really struggling to try to figure out how he can justify his decision. The basic move that he makes in other places is to sort of shift the burden of justification. It's like a neat old debater's trick to say, well, I don't have to explain why I'm ruling that lesbian, women, gay men, and trans people are included within the statute. I just don't think that the arguments for excluding them are any good. But for people who want a public accounting, whose rights and interests or whose worldviews are at stake, we generally think that they have a right to a kind of public justification. And so I think it's interesting to look at what the justification here might be, even if we have some suspicions about whether textualism is the real drive as an abstract matter, or in this case, in the concrete.
So I have one other question here from the audience of how, if at all, does Bostock get reconciled with the Hoosier wedding cake case that allowed discrimination?
So there's an important passage that Justice Gorsuch's opinion for the court has at the end, where or toward the end of the opinion, where he's bracketing a series of issues that he's saying that this case is not deciding. And important among the things that Justice Gorsuch is saying the opinion is not addressing is the role of religious liberty in relation to some of the anti-discrimination claims that are being affirmed by the court's opinion. One of the things that the opinion is suggesting is that there may be problems with the Religious Freedom Restoration Act as a kind of constraint on the meaning and scope of Title VII's anti-discrimination provisions. One of the things that I think is both interesting and important to point out, though, is as a statutory constraint on the operation of another statute, if it is in fact the case that Bostock's justification is grounded in a deeper set of constitutional values, the configuration of those arguments, not statute against statute, but statute against constitutional claim, or really what will be religious liberty grounded in the Constitution against other kinds of equality claims grounded in the Constitution, are what the clashes are really about. So we have to wait and see what the meaning and scope of that sort of carve out at the end of the decision will look like. But I think that there's some reason to safely assume that there will be some limits placed on the meaning and scope of the ruling, but the limits may not be as broad or as deep as I think some people might fear.
Yeah, and that actually leads us nicely to our next case. I have to just say one other thing I think that's fascinating to me about the decision is that it was a 6-3 decision with Chief Justice Roberts joining the majority as well, which is interesting. If we had another hour, I think I'd want to talk more about, about how he does that.
Yeah, well, it certainly does preserve the precedents to which the court has since Obergefell committed themselves. So it's in that sense, sort of a highly principled decision that's in keeping with lots of the rule of law decisions that are coming out of the court this last term.
Well, great. Thanks so much, Mark. We got to keep on. I got to keep the trains on the tracks. We're going to our next case, which is Little Sisters of the Poor versus Pennsylvania, which is the contraceptive mandate case under the Affordable Care Act. And to do this, we have our own Camille Hebert, who is the Carter C. Kissel Professor of Law here at Moritz, to talk about this. Professor Hebert is a national expert on labor and employment discrimination law, including pregnancy discrimination and sexual harassment, among other things. She's published widely, not just on US, but comparative to other countries, which is really fun. And she's just going to kind of walk us through what happened in the Little Sisters of the Poor case. So I'll turn it over to you, Camille.
So the case deals with, as Chris said, the legality of the Trump administration's broadening of the exemptions to the Affordable Care Act's regulatory requirement that group health care plans cover contraceptives and preventative care. The majority opinion was written by Justice Thomas and joined by Chief Justice Roberts and Justices Alito, Gorsuch, and Kavanaugh. Alito also wrote a separate concurring opinion joined by Gorsuch, and Kagan wrote an opinion concurring in the judgment joined by Breyer. Ginsburg wrote a dissenting opinion joined by Sotomayor. So this case was decided technically by a 7-2 vote, although I would suggest that 5-2-2 is probably more accurate. As you may know, this case has had somewhat of a tortured history. The original regulations from the Health Resources and Services Administration defined contraceptive services as a form of preventative care for women, but also adopted a religious exemption, first for churches and then for nonprofit organizations with religious objections to covering contraceptives. These regulations also provided an accommodation by which eligible organizations could provide a self-certification to its healthcare issuer or to its, if it was a self-insured plan, to its administrator of the plan, who would then provide the contraceptive services directly to beneficiaries. Religious nonprofits run by the Little Sisters of the Poor challenged the self-certification requirement as a violation of the Religious Freedom and Restoration Act, which generally provides that a law that substantially burdens the exercise of religion must serve a compelling governmental interest and must be the least restrictive means of furthering that compelling governmental interest. The RFRA claim was rejected by the lower courts and the Supreme Court granted cert. The court ended up not deciding that case after the death of Justice Scalia and remanded the case with instructions to the parties essentially to work it out. In another case, however, Hobby Lobby Stores versus Sebelius, the court held that the contraceptive mandate violated the RFRA rights of closely held corporations, citing the self-certification accommodation as a less burdensome alternative to the requirement that those employers comply with the contraceptive mandate. So in 2016, the government attempted to find a way to accommodate the religious beliefs of religious employers and while ensuring the rights of beneficiaries covered by group health care plans to contraceptive, but found no feasible way to do it. In 2017, with the change from the Obama administration to the Trump administration, the government issued new regulations, essentially avoiding the conflict by broadening the religious employer exemption to any employer with a religious objection to providing contraceptives, as well as adding an exemption for certain employers who had a moral objection to providing contraceptive coverage. These employers were not required to comply with the self-certification accommodation. These new regulations were challenged by the Commonwealth of Pennsylvania, alleging that the regulations were invalid under the Administrative Procedure Act. The district court agreed and issued a nationwide injunction against the interim regulations. Final regulations were then issued, which took the position that the department now believed that the self-certification requirement violated RFRA, and therefore the expanded exemption was the best way to deal with the substantial burden placed on the religious rights of objecting employers. Pennsylvania challenged the final rules, and the district court again issued a nationwide injunction. Federal government appealed, as did the Little Sisters of the Poor, who had intervened to defend the religious exemption. Supreme Court, a Court of Appeals for the Third Circuit affirmed the district court, holding that the government lacked the power to craft the exemptions and that RFRA did not permit or compel the exemptions. Supreme Court granted cert. So in reviewing the Supreme Court decisions, it's important to know what the court did decide and what it didn't decide. In particular, the court decided that the Trump administration's religious and moral exemptions to the contraceptive mandate were both substantively and procedurally valid. That is, the government had the statutory authority to issue the exemptions, and it did so in a procedurally correct way. The court didn't decide that the self-certification requirement violated RFRA or whether the exemptions were required by RFRA, although Alito's concurrence wanted the court to decide those issues. So the court first said that the government had the statutory authority to issue the exemptions with the religious and moral exemptions, the regulations with the exemptions. The court looked to 42 USC section 300 GG-13A4, which provides that with respect to women, a group health care plan shall at a minimum provide such additional preventative care and screenings as provided for in the comprehensive guidelines supported by the HRSA. The argument of the states was, Pennsylvania and New Jersey, was that the provision gave authority for the mandate, the contraceptive mandate, but not for the exemptions. The court accepted the department's positions, however, that the words "as provided for" gave authority both for the mandate and for the exemptions. The court made clear that the only question we face today is what the plain language of the statute authorizes. The court went on to comment on, but not decide, the government's argument that RFRA independently compelled the government's solution, or at least authorized it. The court rejected the contention that the government was not allowed to consider RFRA in formulating the exemptions, noting that RFRA provides very broad protection for religious liberty and that the earlier court decisions all but instructed the departments to consider RFRA going forward. Finally, the majority addressed and rejected the argument that the regulations were procedurally invalid because they were called interim final rules with request for comments rather than general notice of proposed rulemaking. Basically, the court said that the notice satisfied all the requirements for proposed rulemaking required by the APA. The court also rejected the argument that the regulations were invalid because there was no evidence that the department maintained an open mind, particularly given the substance was essentially unchanged from the interim rule. The court rejected the open-mindedness test as a judge-made rule not provided for in the APA, which basically provides the procedural requirements agencies must follow. The court said the department's provided notice, gave interested parties the opportunity to comment, and contained a concise general statement of its purpose. That's, the court says, is all the requirement. That's it. That's what the court decided. And that may be very important because it means that a different administration might well take a different approach and that the court might still uphold that new approach given the greater restriction on, such as a greater restriction on the religious exemption, such as requiring the self-certification accommodation requirement or elimination of the moral exemption. The court could presumably decide that the new administration hadn't shown a justification for changing its position, but that would be at least hypocritical given the acceptance of the new approach taken by the Trump administration as compared to that taken by the O'Donnell administration. I assume I'm running out of time since Chris is back on the screen, so let me tell sort of what the implications of the decision, and I'll leave the concurring and dissenting opinions to questions if there are them. Basically, the implications of the decision is that the Trump administration has the authority to issue regulations, but doesn't decide that they might not be struck down on other grounds, including that they are arbitrary and capricious. And Kagan, I think, actually provides a roadmap for explaining how the lower courts might reach that conclusion. Broad range of employers that can evoke the exemptions for both religious and moral reasons means that, and without having to do the self-certification, means that there are a substantial number of women who are likely to lose their right to cost-free contraceptions or preventative care. But given that the court didn't decide the RFRA issue, and since they had the opportunity to, I assume they did not have the votes to, that it leaves open the possibility that if there is a new administration that re-implements the certification, that decision will, that question is still an open question. Court couldn't decide the issue in 2016, didn't decide the issue in 2020. The issue still may come up again. Thank you.
Yeah, that was kind of my question of, what's, I mean, when this case has been reported, it's been reported as a 7-2 decision, but I really view it as almost a 5-4 decision. I mean, like you said, I mean, for those interested in the Administrative Procedure Act, I think Justice Kagan, former professor and Dean Kagan, gives a roadmap in her concurrence on what the lower courts could do if they wanted to strike it down as arbitrary and capricious,
I think that's exactly right.
What are your thoughts on? I mean, do you think this will be a priority in a Biden administration, or to reverse course, or?
I would think that it's very likely that it would be a priority in the Biden administration, only because the preventative care, even though it wasn't technically, it was done by regulation rather than by statute, I think was a significant part of the Affordable Care Act, and contraceptives viewed as a significant aspect of preventative care. I think there's at least a good possibility that while the religious exemption would stay in effect, maybe even but the self-certification requirement likely to go back into effect. And certainly I would not be surprised to see the moral exemption eliminated.
I've got other questions, but are there any questions from the audience or from any of the panelists that kind of want to jump in? Let's answer this one. So if women's ability to get insurance coverage for contraception winds up swinging back and forth based on who's in office, at what point would rules become arbitrary and capricious?
I mean, certainly I've seen instances, you're the administrative law expert, but I've seen instances in which the court has said, right, that the change without a sufficient explanation could be arbitrary and capricious. It seems to me it would be really odd. So if the Biden administration, a Biden administration or other administration, for example, re-implemented the rules, it seems to me it's really odd to say, oh no, you change your rules, we won't give authority to that, given the really big changes from the Obama administration to the Trump administration, including whether providing contraception was a compelling governmental interest and whether RFRA was involved and all of those issues.
Yeah, I mean, it's interesting that, traditionally when we think of arbitrary and capricious review under the Administrative Procedure Act, we actually imagine with change in administrations that agencies can shift in very different directions. And the key is that they just do so with reasoned decision-making, right? Where they go through the process, they check the boxes, the answer, they respond to significant comments and the like. I do think that's changing a little bit, and maybe we might talk about that a little bit with the next case that we get to. I think Chief Justice Roberts and to some degree Justice Kagan care a lot more about reliance interests in administrative law than perhaps in the past. I think that's an interesting kind of way to look at that. There's one more question that we might have time to answer. This one is, we've seen several landmark decisions this term consider whether or not the administration acted in an arbitrary and capricious manner. I'm curious whether you think this is because we have a particularly arbitrary and capricious administration, or if you see the court adopting a more aggressive posture against the administrative state more generally. You have 30 seconds to answer that, Professor Hebert.
Yeah. Well, so the interesting thing, of course, is that the court didn't even decide the arbitrary and capricious issue because it wasn't directly in front of them. That's the lower court didn't strike it down on that basis. But I do think Justice Kagan's concurrence sets forth pretty explicitly why this one might really be arbitrary and capricious, right? So I don't know. Yeah, I don't think I can answer for that for all of administrative law, but I do think it's interesting that the court didn't address that issue, and so case is presumably going to go back down on that issue.
Yeah, and we will get back to that, not the next case, but the case after with Justice Brown to talk about the Daca case, because that's kind of front and center there. Thanks so much, Professor Hebert, for joining us. We're now going to switch gears a little bit and hear from Joshua Dressler, who's a distinguished university professor of law emeritus here at Moritz. He's going to be talking about the Collar versus Kansas case, which is super interesting. Whether there's a constitutional guarantee of an insanity defense, or whether a state can take that away. I don't want to butcher it too much because he'll tell us a little bit more. But Professor Dressler, as all of you probably know on the call, is one of the nation's, if not the leading, one of the leading scholars in criminal law and criminal procedure, has published the treatise on it, and is so excited for him to join us here to talk a little bit more about Collar. So I'll turn over to Professor Dressler.
Thank you, Chris. Indeed, the most important case in my field this year was a substantive criminal law case, Collar v. Kansas. The question for the court was whether it violates the Due Process Clause for a state to abolish the insanity defense, as Kansas has done. The court, per Justice Elena Kagan, by a 6-3 vote, held that Kansas's statutory scheme does not violate the Due Process Clause. But this is important. The court did not say that it's constitutional to abolish the insanity defense. Instead, it defined insanity defense in a very peculiar, and I will suggest, improper way. But let me start by observing that this was not a great case to bring to the Supreme Court if you wanted to show how wrong it is to punish mentally ill people, because Collar was not a mentally disordered person. There are no extreme facts here where he was hearing voices from Martians and the like. This was a case, the facts of which were really all too common. He and his estranged wife were in a custody battle. She took their children, their 2 children, moved out of the home into her mother's home. He then broke into his mother-in-law's home, and he murdered his wife, his daughter, his mother-in-law, but let his son, who was supportive of him in the custody battle, leave unscathed. This was a man with anger management problems with a gun, nothing more, all too common in this country. Yes, Collar's attorney came up with an expert willing to testify that Collar suffered from severe depression, so severe that, quote, at least for a short period of time, he completely lost control of his faculties. Well, not so completely that he couldn't distinguish between his son and the others, but okay. But he couldn't introduce even this weak evidence to prove insanity because, as I said, Kansas abolished the insanity defense. Instead, Kansas applies the so-called mens rea approach. That is, a defendant may raise mental illness evidence, but only to disprove the mens rea element in the definition of the crime. In this case, the intent to kill. That provision, however, didn't help Collar at all because there was no question that he intended to kill his family. In fact, his mother-in-law's security system recorded Collar saying, among other things, and I quote, "Oh shit, I'm gonna kill her, God damn it." So needless to say, all of the elements of capital murder were easily provable and proven. Now, it's also the case that under Kansas law, Collar was entitled to introduce mental health evidence at the sentencing phase to try to mitigate his punishment, in this case, to try to avoid the death penalty. He failed. He was sentenced to death. Okay, that's the background. Now let me talk about what the court said. First, Justice Kagan stated that, quote, within broad limits, doctrines of criminal responsibility, such as the insanity defense, remain the province of the states. Anyone, therefore, who seeks to use the Due Process Clause as a basis for compelling a legislature to adopt a particular rule of criminal liability must, she said, surmount a high bar. Namely, here, as Kagan put it, the question was whether a, quote, single canonical formulation of legal insanity is so old, so venerable, so deeply entrenched that the Due Process Clause compels the state of Kansas to adopt it. Whoa, notice, the issue was supposed to be whether the Due Process Clause imposes on the states a requirement that they recognize an insanity defense, not whether the Due Process Clause imposes a single canonical formulation of the defense. If you ask the wrong question, you get the wrong answer. But there's more. The majority conceded that, and I want to quote this very directly, the majority conceded that Collar is right that for hundreds of years, jurists and judges have recognized insanity, however defined, as relieving responsibility for a crime, end of quote. So the question is, how could the majority concede, I'll quote it again, that for hundreds of years, jurists and judges have recognized insanity, however defined, as relieving responsibility for a crime, and yet still find that Kansas, which has abolished the defense, is acting constitutionally? Well, here's Justice Kagan's answer for the court. Lo and behold, she says, Kansas has an insanity defense. Why? Because it allows the defendant to introduce mental health evidence to negate the mens rea of the crime. And significantly, Kagan goes on, mental illness evidence is admissible at sentencing. Ergo, Kansas has an insanity defense. Okay, wait a minute. Imagine a defendant is charged with failure to obey a police officer's order. And his defense is that he was deaf, so he didn't hear the order. Under ordinary rules of criminal law, the defense would surely be permitted to put on evidence that he's deaf and didn't hear the order. But we wouldn't say that therefore the law has enacted a deafness defense. Instead, we would see this as just the ordinary rules of liability. The government must prove all of the elements of a crime beyond a reasonable doubt. And that's true whether the evidence happens to involve deafness or mental illness. To suggest, therefore, that a defendant who introduces mental illness evidence in order to raise a reasonable doubt regarding mens rea, one of the prima facie elements of a crime, is thereby raising an insanity defense, is to extinguish the distinction between asserting an affirmative defense on the one hand and merely casting doubt on the government's case in chief on the other. Surely every justice who signed on to the majority opinion understands that distinction. Who did they think that they were fooling? And then to suggest that if a person has been convicted of a crime but may introduce evidence to obtain a somewhat more lenient sentence, that this is an insanity defense is even more preposterous. So where does that leave us? Well, what we learned from this case, what Kansas learned from this case, is that they do have an insanity defense, even though they didn't think they did. The real issue now remains, and that is, what if a state abolishes the true insanity defense and also bars mental health evidence both during the trial and at sentencing. No state, thankfully, has gone that far, and so that issue remains up in the air. Thank you.
So this is fascinating. I could listen to Professor Dressler all day. I wish I had you for my criminal law course, but I was curious, and I was surprised to see this as a 6-3 decision with Justice Kagan writing the majority decision. Any thoughts on why that's the case?
I told my students that I actually thought the case was going to go 7-2 rather than 6-3. I was surprised that Justice Breyer wrote the dissenting opinion. Justice Kagan has not, let's just put it this way, she's not as friendly to the criminal defense side in criminal procedure issues or, in this case, substantive criminal law. Yes, she votes most of the time on the liberal side, on the defense side rather than the government side, but she's expressed doubts about the Fourth Amendment exclusionary rule and things which make her a plus with the conservatives.
Do you think there was any, is this kind of a classic move to try to get a narrower decision than would have come out of her 5-4? Or do you think it's just kind of straight up where she's at?
Well, as I say, I thought it was going to go 7-2. If you go back to the 1960s, the Warren Court, back when that court was extremely activist for criminal procedure areas, the Supreme Court back then was actually very much conservative about substantive criminal law. Justice Marshall back then made it very clear that basically states can do whatever they want in terms of defenses and how they define crimes. So if that was true back in the activist days of the Warren Court, it's not surprising that it happens now.
The other kind of question I had was, what's the practical impact of this? Do you think states will actually now feel like they have the green light to start getting rid of it, or?
I think that it may increase the number of states, yes, that will abolish the insanity defense, but again, they would, at least right now, presumably have to allow mental illness evidence during the trial for mens rea purposes. I doubt we'll ever see a state try to say that mental health evidence can't be used for anything at all. And I think that if any state went to that extreme, then I think there's at least a decent chance that the court would shoot that down.
Yeah, at the sentencing phase in the capital case, that would be, I have a hard time seeing how the court would get there. I guess you never know.
Yeah, no, I don't think they would ever do it in that area, given the case law in the area, but what about in non-death penalty cases?
Yeah, that's right. Well, this has been so much fun. Thank you so much, Professor Dressler, for joining us. And I would say the other interesting case, at least one of the other interesting criminal law cases, is the Ramos versus Louisiana case on whether unanimous juries or not, which maybe another day we'd have a chance to talk about that. But that also was another one that really stood out to me. Thanks so much for joining us. So now we're going to switch back to administrative law. I swear it's not just because I helped organize the panel that we're talking about administrative law a lot, but for this one we have a really special guest, Justice Yvette McGee Brown. I can't think of Justice Brown other than as Justice. She's currently, though, a partner at Jones Day here in Columbus, but before that she served on the Franklin County Court of Common Pleas for nearly a decade before she joined the Ohio Supreme Court in 2011. She's, of course, we are very, very proud of her as an alum as a double alum, double Buckeye, but here at the law school here at Ohio State. And I just wanted to thank you, Justice Brown, for your tireless service to this state and for all the people you've inspired that attend our law school to get out in the community and serve and lead. You're just such an inspiration, and I'm just really proud to count you among our amazing alums. So today I'm going to turn over to Justice Brown, but she's going to talk to us about the Daca case, which is the deferred action case, and the Trump administration's decision to rescind this immigration relief program that the Obama administration had established. I'll turn it over to you, Justice Brown. Thanks so much for joining us.
Thank you, Chris. And I do have to say, for my Bobcat friends out there, I'm an undergrad Ohio University, so they always get upset when I don't acknowledge them. So it's great to be with you. And I have to say, Chris, I never imagined in law school I would spend this much time learning about the Administrative Procedures Act. But I do think this case is really important for a couple of things. One is it's another case focused on the Administrative Procedures Act. And as you stated earlier, the amount of focus it puts on the reliance interest. And quite honestly, I think that's because it involved over 700,000 people that Justice Roberts, with the majority, spent so much time talking about the reliance interest. But just as a bit of background, this is the Daca case out of 2012, President Obama's Deferred Action for Childhood Arrivals program, that he had DHS, Department of Homeland Security, issue instruction to ICE, the Immigration and Customs Enforcement. You'll see there's a lot of acronyms in this area of the law. I'll try not to overuse them. But basically the memo to ICE instructed two things. One is they were to exercise prosecutorial discretion on an individual basis by deferring removal action for a period of 2 years subject to renewal, and to accept applications to determine whether these individuals qualify for work authorization during this period of deferred action. And so the decision really rests on two stools: forbearance and the provision of benefits. So that was in 2012. In 2014, DHS issued a second memorandum expanding DACA eligibility and creating a related program for parents called the Deferred Action for Parents of Americans and Lawful Permanent Residents. Now, if this program had been implemented, it would have granted DACA-like rights to 4.3 million parents of US citizens or lawful permanent residents. Texas, joined by 25 other states, secured a nationwide injunction barring the DACA expansion. The Fifth Circuit upheld that injunction, concluding the program violated the Immigration and Nationality Act, which carefully defines benefit eligibility. It was on this basis and new policy priorities that the Trump administration in 2017 rescinded DACA. On June 18th, in a 5-4 decision that was authored by Chief Justice Roberts, the US Supreme Court ruled that the Trump administration's attempt to rescind DACA failed to comply with the Administrative Procedures Act. And what's interesting, and what you'll hear from in a bit, the dissent, Justice Thomas, is very aggressive in saying it didn't need to comply with the Administrative Procedures Act because it was never subject to rulemaking in the first place. The court also found that the respondents had not proven a violation of the Equal Protection Amendment, from which Justice Sotomayor was the only justice that dissented on those grounds. So let's talk a bit about the Administrative Procedures Act. It establishes a basic presumption of judicial review for one suffering a legal wrong because of agency action. This presumption can be rebutted by showing that the agency action is committed to agency discretion by law. This generally includes that an agency's decision not to prosecute or enforce. DHS argued that the decision to rescind DACA was not reviewable because it was a general non-enforcement program. The court rejected that argument, finding that DACA conferred affirmative immigration relief and therefore was reviewable under the Administrative Procedures Act. The court also finds that DHS failed in looking at the Administrative Procedures Act to take into account serious reliance interests resulting from longstanding policy. And if an agency fails to do that when it changes course, its actions are arbitrary and capricious. Justice Thomas in a strongly worded dissent, stated that rescission of DACA was not only permitted, but required because the program was unlawful, and therefore questions of whether the rescission was arbitrary and capricious should not have been reached. Thomas argued that DACA was unlawful for two independent reasons. One, it altered immigration law in conflict with the Immigration and Naturalization Act by unilaterally conferring eligibility for lawful presence. And two, DHS, as I said earlier, did not engage in the administrative rulemaking process when it initially implemented DACA. Thus, DHS did not have to consider preserving DACA's forbearance provision when rescinding the program. Thomas argued that DACA was a substantive rule that contravened statutory limits. Because it was not subject to administrative rulemaking process, it was unlawful when implemented. Justice Alito, while he joined Thomas's dissent, also wrote a concurring opinion criticizing the judiciary's role in hampering the Trump administration's ability to rescind DACA for an entire term without ever ruling on whether the program was legal, and basically telling DHS to try again. Justice Kavanaugh criticized the majority for not considering subsequent justification that Secretary Nielsen had provided for rescinding the program, and then stating that the decision would have very little impact given that DHS can simply do it again with more substantive reasons. And then Chris informed me shortly before we came on air that apparently DHS today has issued a new DACA rescission policy, and we'll see where they go with that. I've not had a chance to look at it. On the equal protection challenge, respondents claimed that the decision to eliminate DACA was motivated by animus, thus violating the equal protection guarantee of the Fifth Amendment. Roberts, writing for the plurality here, stated that the respondents failed to successfully plead animus, stating that they failed to raise a plausible inference that an invidious discriminatory purpose was the motivating factor. He said the way to accomplish this was by showing evidence of three things. One, a disparate impact on a particular group. Two, a departure from normal agency procedures. And three, contemporary statements made by members of the decision-making body. Justice Sotomayor, in her dissent to the equal protection ruling, said that the respondents had successfully cleared the threshold. The plurality should not have dismissed statements made by President Trump. They should not have minimized the disproportionate impact of the rescission on Latinos, and the plurality bypassed the context surrounding the abrupt change in DHS's DACA policy, which to her suggested something other than questions of legality motivated the decision. So what does this mean going forward? Well, we know today that there's a new memorandum that's going to attempt to rescind the program. I think to the broader point that Chris raised earlier is that it also is interesting that as Congress remains gridlocked in substantive issues that we need to address, it appears the power of agencies, in my opinion, is increasing with the use of the APA or executive orders. There are scholars that have written that this decision could mean that presidents on their way out of office are invoking lots of executive orders that it will be hard for the successor administration to overturn. In fact, in the New York Times on Sunday, John Yo, I think that's how you say his name, who famously wrote the torture memos in the Bush administration, has suggested to President Trump that he can do whatever he wants and it will be hard for any successor administration to overturn that. I think most scholars think that the DACA decision is so narrow, and some say self-contradictory, that it precludes confident generalization beyond the examples at hand, but we'll see. Chris? You're on mute. You're on mute.
So this is really great. I mean, it's an interesting decision because, as you noted, and Joan Biscook is doing this 4-part series for CNN right now. She's interviewed she's got a lot of leaks at the Supreme Court this term, probably the most I've seen in a while. But she noted that there was a big push not to have a separate decision from the majority, just have Chief Justice Roberts, but Justice Sotomayor just wouldn't have it. I mean, she really wanted to make it clear that there was enough there on the equal protection case, which I thought was interesting. Yeah.
Well, I have to say that while I like the outcome of this case, legally it feels a bit dubious to me. And I will concede that I'm not as smart as the 5-person majority, but it does seem to me that to say that a program that was never subject to administrative rulemaking has to be considered under the Administrative Rulemaking Procedures Act seems a bit disingenuous to me, but you're my expert on that.
Well, I mean, the whole oddness of it all is that the first challenge to the DAPA and eventually the DAPA is kind of the expanded version of the Obama administration of this program that applied to parents as well, was that it had to go through rulemaking, right? And so you had this kind of odd, everyone changed hats, like Texas was on one side before, and now California and Hawaii are leading the charge now, which isn't unusual for administrative law, but that is kind of one of the interesting wrinkles here. I think you're entirely right that the way that Chief Justice Roberts wrote this opinion in some ways makes it maybe good for this day only. Although on the flip side, there's a lot to these reliance interests, and also, as you mentioned, to the idea of considering alternatives that are short of kind of the breadth here. So I've got a question from the audience. One of my former students, Ruben Garza, who's a little bit of an administrative law geek. So he says that with this case and with the census case from the term before, do you think that administrative law litigation going forward will focus more on procedural arbitrariness and capriciousness, or more substantive issues of law?
That I don't know. I think with this decision, I mean, it depends on how much traction the reliance interest gets. I can tell you now, representing private clients, it becomes a bit frustrating when you are suddenly subject to executive order policy decisions and administrative rulemaking that changes with every administration. So I think it's going to depend, like here, what are you going to do with 700,000 people who have relied on an executive order saying that if they register and file an application, they can stay in this country? So I guess my short answer would be, if there is significant reliance interest, I think it's going to be easier for the court to find arbitrariness if there's not a lot of consideration given to an alternative pathway.
Yeah, I agree. I think we're going to see, what is good for one administration today or bad for one will be, the same on the other side in some ways. And I do think there is going to be a little bit more of this case will have more legs, I think, than just good for this day only because of that reliance point that you point out. So thank you so much, Justice Brown, for joining us today and for your service and everything else. I really appreciate it. We're going to switch to our next case. Now, we're not moving away from administrative law. We're now going to look at two of the kind of related blockbuster cases, separation of powers cases with respect to the president and whether the president's financial records can be subpoenaed, either in a criminal case or by Congress. These are Trump v. Mazars and Trump v. Vance. And for this, we have although we haven't been in our offices in a while, I have the one I share my office wall with, Peter Shane, who is the Jacob E. Davis and Jacob E. Davis II chair in law here at Moritz. He is one of the nation's leading scholars on presidential power and separation of powers between the branches of government. So I'm going to turn over to him to talk about, he has to talk about two cases in 8 minutes, but we'll see how we go about these two really important cases about how the subpoena power over presidential, personal records of a president. So I'll turn it to you, Peter.
Thanks, Chris. And you're right, this isn't as much fun or as convenient as when we get to see each other in the hallway outside our offices, but it's still good to see you. And it's great to be speaking to so many of our alums. I hope everyone is as safe and as healthy and in as good spirits as these very stressful times permit. The two subpoena cases that Chris mentioned are Trump versus Vance and Trump versus Mesos. Trump versus Vance involved the state grand jury subpoena for the president's tax records. Trump versus Mesos is actually two consolidated cases that dealt with a total of 4 congressional committee subpoenas emanating from 3 committees for a variety of his financial records, not tax records, but financial records involving either himself or members of his family or businesses with which he is affiliated. And these cases, of course, were decided amid some expectations of great drama. The decisions came very, very late. I think some people were thinking perhaps the court might force the immediate release of some bombshell documents just as the presidential campaign season was heating up. And others might have anticipated that this would be a victory for the president, which would enable him quite clearly to resist oversight either by state criminal law or by Congress. And we didn't get either drama. There was no immediate release of any documents that's now anticipated, but there was also no vindication of the president's legal position. Chief Justice Roberts wrote both opinions, and both, I think, show his skill at protecting the court from appearing unduly politicized. And I think his strategy in these cases, as we've seen in others, is to adhere to what he regards as normal separation of powers principles. And there can be disagreement over what's normal, but I think he's pretty clear about what he considers normal. And I think there's good reason to he was on decent ground in taking his position. We saw in Trump versus Hawaii, which decided a couple of years ago, this is the travel ban case, or maybe the revised travel ban case, that Chief Justice Roberts, writing for a majority of 5 in that case, insisted on what he considered normal principles to the president's advantage. He insisted on that the court should not intensify its review of a presidential proclamation in the national security field, despite the president's highly irregular remarks on the subject of immigration. But here, being normal, if I can use that word again, worked against the president because Chief Justice Roberts and the majority would not expand presidential immunity for private records as to which there was no available executive privilege argument. So to take each of these cases in turn, in Vance, this is the criminal law case out of New York, the court unanimously rejected the proposition that presidents had absolute immunity from state criminal subpoenas. Nobody took the position that the president had absolute immunity. The main opinion, however, was written by Chief Justice Roberts for himself and for the 4 more customarily liberal bloc, expressly discounted the arguments that the president was making for immunity. His arguments were that having to respond to these subpoenas or be the subject of a grand jury investigation would divert his attention from his official duties, would subject him to stigma, kind of destabilizing the executive branch. And by the way, the Justice Department did not even try to make that argument on his behalf. And the last point was that it would open up the potential for presidential, for the harassment of the president by ambitious or overly partisan prosecutors around the country. And here again, you see normalcy emerging, because what normally happens when you challenge a criminal prosecution is that prosecutors get the presumption of good faith and regularity, and that's exactly how the majority treated the subpoena in this case. The majority also rejected the idea that a state grand jury subpoena has to satisfy some so-called heightened need standard, that this was not just something relevant to the investigation, but that they had a especially intense need for receiving the documents that they were requesting. They found that the subpoena on its face didn't threaten any impairment of the president's constitutional functions, since these papers have nothing to do with his functions as president. The majority reasoned that anyone faced with a subpoena in a state state or local grand jury proceeding has the capacity to raise a number of issues or defenses under ordinary state law, and that the president could raise those issues as well. Questions about the appropriateness of scope, whether the subpoena was posing some sort of undue burden, or whether there was some other privilege, not executive privilege, implicated. And the president could raise those issues in a New York court. But these would not be issues for federal law. Now, it was 7-2. Justice Gorsuch and Justice Kavanaugh wrote separately, and where they departed from the majority was really only, at least as far as I can tell, in their view that the ordinary standard that would apply in an executive privilege case of what the Supreme Court has called demonstrated specific need should be the constitutional standard when going after the president's personal records. Honestly, it's not clear to me, and I think the majority, Chief Justice Roberts made this point in his opinion, it wasn't clear to him either how different, or maybe it was Justice Kavanaugh who said, it's not really clear how different the standard is that Justice Kavanaugh was arguing for as opposed to the standard in the majority opinion. But in any event, at least as a matter of formal doctrine, there is no special need standard that applies when a grand jury seeks the personal records of a president on a matter over which executive privilege is not relevant. The more interesting, I suppose, separation of powers case, the other, I guess, really advances more of a federalism case, is the Mesos case, which was consolidated with a case called Trump versus Deutsche Bank. And as I mentioned, this involved a total subpoenas that came out of 3 committees. There were 4 subpoenas in total, involving the president, his children, other family members, or affiliated businesses. And each committee, when in defending its subpoenas, had claimed that the information being sought was somehow relevant to legislative matters within their jurisdiction. The lower courts in both of these cases upheld the subpoenas by a split panel. Each of the lower courts thought that the relevant committees had said enough about the relevance of what they were asking for to their legislative function for the committee subpoena to be enforced. But the Supreme Court disagreed, really purported to disagree on that. That is, the Chief Justice, writing for himself in the majority of 7, faulted the lower courts for not undertaking what he called a careful analysis that takes adequate account of the separation of powers principles at stake. And this gets almost metaphysical, because on one hand, he said, again, we're not applying any heightened standard here, but we are expecting the lower courts to engage in a series of inquiries that are careful. And he said this is not necessarily an exclusive list, but the court should at least ask whether other sources of information were available to Congress that could supply the same information that they were looking for, whether the subpoena is any broader than it needs to be given their legislative objective, whether they've identified their aims and explained how the president's information will advance their aims adequately, and also whether they had carefully assessed whether this releasing the records would be a burden on the president. Since the subpoenas were actually not directed to the president personally, that last one should be pretty easy in this case. Justice Thomas, in dissent, advanced a theory that his former clerk, Judge Naomi Rao on the DC Circuit, had advanced in dissent on the Mesos case, which was that Congress should not be able to look at the personal records of an individual at all in what amounted to a law enforcement context. And with regard to the president, they could do it only if they formally invoke the impeachment power. Again, no other justice on the court adopted that, although Justice Alito said, this was a valuable opinion to have written. Justice Alito, for his part, simply said that, well, again, if I understand his opinion, which was not entirely clear, but he would have applied some kind of heightened standard. And he was pretty clear that what he saw in the records would not have met that standard, at least in the case so far. SCOTUS, the Supreme Court, avoided by deciding the cases in this way and having any seismic effect on the 2020 election, which I think was the Chief Justice's, was one of his key concerns. The lower courts have a clear framework now for analysis, although they might have thought they'd actually already answered those questions. They just hadn't framed their opinions quite that way. The president's records are not going to be made public before the election. This is pretty clear. But Congress has won a victory, at least on the scope of its investigative authority, which the majority said, contrary to the president, was every bit as broad as its legislative authority.
Yeah, so you kind of took my first question was, are we going to see any financial records before the election? And your answer is no way. Is that?
I don't think so. As you may have seen, formally, a judgment doesn't go forth in the Supreme Court, I gather, until something like 20 or 25 days after the opinion. And the House asked for the judgment to be issued earlier and going to the lower courts so they could get to the lower courts yet more quickly. And the Supreme Court denied that motion. So the wheels of transparency are going to move slowly in this case.
Yeah, so there will be no October election surprise.
Right. Not October of 2020 at any rate.
Yeah. I was kind of curious. So if Congress wants to do this, again, I am struggling to understand what the lessons are from the majority decision on what Congress has to do differently if it wants to be able to get, the records and another try at this.
Well, I think, this is another one of Chief Justice Roberts' square corners opinions, which is just as Justice Brown was describing the Daca opinion. It's sort of like, there are things you can do, but you can't cut corners. And the corner that the Chief Justice does not want to cut is a kind of detailed explanation. And I take it that this opinion, he said what he means and he means what he says. He would be prepared to uphold these subpoenas if the courts and Congress had kind of offered their analysis within the precise framework he had offered. The one thing I would just, if I editorialize on something, I guess is you would agree with this, Chris. I think the House lawyering in the Supreme Court at oral argument was awful. And one of the opinions that, one of the questions that the lawyer absolutely flubbed was, if we take your point of view and if we accept your argument in this case, give me an example of some presidential document that would not be discoverable by Congress, which has to be the first question that would be asked at any mooting of this argument. And yet he completely, he had no answer. It really was a disastrous performance.
Yeah.
Yeah.
I think that was actually a real turning point in the case, in a lot of, not being able to. And I kind of wonder, so the attorney is one of my mentors from the Justice Department.
I'm sorry, I didn't mean to put you on the spot.
A dear friend, an amazing lawyer. But I do kind of wonder, was it strategic or not? Did they decide they didn't want to try to put a limiting principle on it? If it was strategic, I think it was a bad strategy.
Right. Well, one thing he could have said, and the majority opinion does say, that the president's records cannot be sought as kind of a case study as to a general problem. We're interested in deciding whether people who went to college in Pennsylvania, are more likely to, have some problem with interstate commerce. So let's see. Here's who went to college in Pennsylvania. Oh, President Trump. Let's investigate him. Now that can't be.
Yeah, no, I agree. I also completely agree. This was one of the most obvious questions that was going to be asked. So it wasn't like it should have been a surprise to anyone. Well, thank you so much, Professor Shane, for joining us. We are now moving to the last case. We've kept everything running on time. And if there are any questions in the Q&A, feel free to chime in. We can answer them offline as well if you have questions. Our last case is we're turning to the Faithless Electors case. And of course, if we're going to talk about elections here at Moritz, we're going to have Professor Ned Foley on to talk with us about it. He is the Charles W. Eversold and Florence Whitcomb Eversold Chair in Constitutional Law. He also directs our nationally leading election law at Moritz program. He's written a book on elections, Ballot Battles, back in 2016, which is about disputed elections. And his latest book just came out, Presidential Elections Majority Rule, with the Oxford University Press just a little while ago. And so I'll turn it over to Ned to talk to us a little bit about this Faithless Electors case.
Thanks, Chris, and it's great to be with all of you. And I guess I should disclose that that recent book has some history that is relevant to this discussion. The Faithless Elector case has the virtue of being unanimous, although there was a separate opinion. So it wasn't one of the most divisive opinions. It's an important case in its own right, but I think it's also important for what it could signal potentially, going into November. So a little bit of background, and then we'll try to think about the implications. So I think we all know as lawyers that we don't really get to vote for president. We get to vote for these presidential electors, even though we think of it as a presidential election. And the electors as human beings are kind of a vestige of history. You could think of it as kind of the appendix of the Constitution. It might have had a function, but it doesn't have a function anymore. And the court is kind of worried that maybe the appendix will cause appendicitis, and how can we avoid a disaster with this vestigial instrument. And so, in most elections in American history, there might have been a faithless elector. Again, that term can be a little bit controversial. Sometimes they're thought of as conscientious electors. Sometimes they're called Hamiltonian electors after Alexander Hamilton and his Federalist Papers description of electors having the right to be deliberative and make their own independent choice. But they're called faithless electors by many people because of the historical development and the expectation that the electors will just be completely ministerial and just vote the way the popular vote in the state goes. They became significant, or potentially more significant, as you all may remember, in 2016, because there was a kind of a movement after the popular vote in November of 2016 and the surprise of many people that Donald Trump was winning the Electoral College based on the popular vote in all of the states. There was some hope among some people that by the time the electors would meet in December of 2016, that enough of them might go rogue, as it were, be faithless, to throw the election into the House of Representatives, which is the backup mechanism of electing a president under the 12th Amendment, which we've only utilized once or twice, depending on how you count it. We did it in 1800 based on the original Electoral College system. And then in 1824, under the 12th Amendment, those two elections did go to the House, but we haven't had to rely on that fallback procedure since then. So I guess we need a little bit of review of history. Some of you may be familiar with this from college or high school or just from following this case. But I think the most important thing to understand is that our Electoral College is not the original Constitution, but the 12th Amendment. So that's what the Supreme Court was interpreting in this Chiafila versus Washington. That's the name of the case. There were two consolidated cases, one out of Washington, state of Washington, one out of the state of Colorado. Again, the case arose as a result of 2016. The effort on the part of getting electors to be faithless in favor of going to the House of Representatives failed. Trump only lost 2 votes in the Electoral College due to faithless electors. Hillary Clinton actually lost more, but it all kind of fizzled out as a movement, and the election never did go to the House of Representatives. But some of those electors who wanted to be faithless back in 2016 were punished for being faithless. In Washington, the punishment was a fine, and so they contested that. In Colorado, the punishment was being removed for the office of being an elector because you were faithless, and a substitute elector was appointed to do the right thing. And those two cases got to the Supreme Court and were consolidated. But back quickly to the history. The original Constitution, I think it is fair to say that Hamilton, in writing in the Federalist Papers, was correct in saying that the concept was deliberation, right? The idea was that the electors would exercise independent judgment and pick a consensus choice, somebody like George Washington, on behalf of the nation. But the system broke down as soon as George Washington left the stage after 2 terms, and partisan politics developed. And that happened first in 1796, and then with the amazing election of 1800. If any of you saw Hamilton recently on TV or on stage, you know something of the story. It's a really great story where there's this tie vote between Thomas Jefferson and his running mate, Aaron Burr, that goes into this deadlock in Congress. And Hamilton kind of helps break the deadlock by saying, even though he hated Jefferson's politics, at least Jefferson had politics and principle, whereas Burr didn't have any. And of course, then Burr kills Hamilton later. We all know about that. But what's important, I think, from understanding the transition from the original Constitution to the 12th Amendment is the development of political parties. The founders of the Constitution in Philadelphia and the Convention wanted to avoid political parties. They thought they could do that through separation of powers. Obviously didn't happen. And then the founders themselves have a schism. And you have even Madison and Hamilton, even though they wrote the Federalist Papers together, they end up falling apart. And Madison joins Jefferson in one political party, and Hamilton joins John Adams in another political party, and their politics are as ugly and as polarized as politics are today. And as a consequence of that, after this debacle of 1800, the Jeffersonians, who control Congress as well as the presidency and are anticipating Jefferson's reelection in 1804, write the 12th Amendment to say, we've got a new electoral college system that's going to be based on the principle of majority rule, recognizing that there's not going to be consensus anymore. It's just going to be either a majority choice or not a majority choice, but it's going to be political. How that matters for purposes of the Faithless Elector case is that Justice Kagan, writing for the court, says that the text of the Constitution is on the side of allowing states to ban faithless electors and limit that. And the historical development that I've been describing, again, is for the development of political parties and away from this idea of deliberation or discretion. And so looking at Article 2, as well as the 12th Amendment, Justice Kagan writes for the court saying the state can do this. Now, at oral argument, there was a principle invoked of avoid chaos. And I think that's a subtext of what the court is doing here. They thought that if they allow faithless electors, again, we might have this appendicitis problem, and they were trying to do everything that they can to avoid it. And Justice Kagan's opinion's a fun read. It refers to Veep, it refers to Hamilton, as I have. So I encourage people to read it if they haven't. But the thing to realize is what it doesn't say. The court says that states can stop faithless electors, but it doesn't require that they stop faithless electors. So we may still have chaos, even if the court would like to avoid it, because 18 states don't have the kind of rules that Colorado and Washington do. And so it could still happen despite the court's desire to avoid it.
So
Thanks,
this
Chris.
is great. So we've got a question from the audience of, were you surprised that it was a unanimous decision? The arguments in favor of striking down the law, he thought would gain some traction with originalists. I mean, did you think that there might be some dissenters here? Or?
Based on oral argument, I was not surprised. Maybe before oral argument, I would have expected more division. I think this case is a really good lesson for all lawyers to not just read court opinions, but to read the oral argument. Because again, if you read the opinion, you don't see an explicit mention of this chaos principle. But if you go back and listen to the oral argument, you understand some of the justices' motivations. So I do think a kind of honest originalism would have grappled more with the Hamiltonian view than what emerges. But I think Justice Kagan, fair to her, is that the originalism of the 12th Amendment is a lot more complicated than the originalism of the original Constitution.
Well, we are out of time. This has been a fun 90 minutes. I want to thank you, Ned, for joining us and talking about this, and go out and buy his latest book that just came out in Oxford. It is on I've ordered it. I have not started reading yet, but I look forward to reading it once I get it. But just wanted to thank all the audience for joining us. We obviously only covered a few of the cases from this term. There were lots of other really interesting ones, and I've put up a link if you want to go and look at the rest of the ones on SCOTUS blog. They've got great summaries of each of the cases. I mean, some of the ones that strike me as particularly interesting that we didn't cover is there's the McGirt case about federal Indian law in Oklahoma that Justice Gorsuch wrote the opinion for the majority on. That was really fascinating. We had the Selah Law case about the constitutionality of the Consumer Financial Protection Bureau, or at least the head of the Bureau, who at one time was Rich Cordray from here in Ohio. There were a number of other cases. There was a ministerial exception case under the First Amendment that was really kind of fascinating. So definitely go and check out the rest of them. But I wanted to thank you all for joining us, and in particular, thank all of our panelists for taking the time to go through this. Just wanted to kind of, in conclusion, flag for you, for those that are interested in getting CLE credit, you've been answering the poll questions. Within the next 48 hours, you'll get a course evaluation form, which you need to fill out in order to get CLE credit. So definitely check your email box. If it's not in your inbox within 48 hours, check your spam and or trash folder. And you also need the activity code 441443 for your records in order to get the CLE credit. I have to just, at the end, just thank the development staff here at Moritz, and particularly Amy Gallagher for putting this together. We have such an amazing group of faculty and alums here at Ohio State that follow these cases closely at the Supreme Court. And it's so great, even though we can't interact in person as we normally would, to be able to interact here on Zoom to talk about these important cases and the direction in which the court is going in the years to come. So on behalf of the college, I wanted to thank all of you for joining us. We'll have another one of these in the fall, which is a preview of the coming term, and I hope you'll join us for that as well. So thanks so much.